Seems very, very straightforward to me. But the judge is very, very slippery. He's very slippery and really moves the goalposts.
Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings.
Okay, here's the issue. Here's the issue with the death penalty motion, guys. I mean, there's a lot of issues with it. I do not have a lot of confidence after hearing Judge Hippler's comments about this that he appreciates what the duty to investigate is. You don't get to take the state's word for it. The entire case is an allegation by the state. You don't get to just take their word for it. You have a duty to investigate it, and you are ineffective if you don't. So this idea that we can just ask the state, well, do you have anything? Is any of that important? Are any of the tips substantiated? That's not investigation. They have to review it themselves. They have to make their own independent exercise of judgment. And there's so much case law about this that you can reasonably restrict your investigation, but only to the extent that you have a basis. You have a basis in reason for being able to do that. Not just I didn't have time, not just it didn't seem important. And the fact that this is a capital case and it's a heightened responsibility is extremely alarming. But here's the thing that's worse. You have a right to effective assistance of counsel in non-death penalty cases also. You also have a right for your attorney to be informed about whether you should be convicted or not, regardless of what the penalty is. So if trial counsel isn't prepared to be able to meet the evidence and make a case, and that's in the record now. This is in the record. They have made a strong record. We haven't reviewed everything. And we can't, and we won't. That is now in the record. That goes to the validity of the conviction just as much as it goes to any penalty that gets imposed. So, I mean, it's a mess. It's a mess. I don't know what you do about this other than continue the trial. I really don't. You can't have a case go forward to trial where defense counsel is telling you, I'm not prepared. I don't have time to prepare. Here's a record of what I haven't done. Because anything in there that could help, you've now given them a post-conviction issue. It's really, really not prudent to do that. Maybe he's willing to gamble on the state's word. It sure seems like he is. But the defense can't. They're not allowed to, very explicitly, not allowed to just take the state's word for it. Take the state's witnesses for it. They don't. They have to look at it themselves. They have to make their own determination. So, yeah, I'm really not thrilled with what it kind of sounds like here as far as Judge Hippler's understanding of defense counsel's roles and obligations. When Ms. Jennings was talking about the defense's motion is just replete with these misrepresentations, where was the outrage about that? Wasn't that the type of accusation that we said we weren't supposed to be doing? But it's not a problem. It's not a problem if the defense, if the state gets up there and impugns the defense counsel's litigation of their issues. You can get up there and say they're misrepresenting things, and that's okay. No, they're advocating. You can say they're wrong about certain things, they're mistaken, but you're up there calling them liars to make their point, and where's the outrage? That's only for Mr. Ray? That's only for Mr. Ray? I really would like to see some of the same energy being shared. Doesn't seem like that should be, a real egregious expectation. Is that hard to treat both parties the same? If you're going to get all upset about him doing it, shouldn't you at least tell her, Ms. Jennings, I just told you guys not to do that kind of thing? No, it's just, completely gone by unpassed, no comment on it. And guess what? Because of that, she's going to continue to do it. It's a habit that she has. She likes to call the defense liars just as much, if not more, than they have called her one. So just maybe pay attention to that, Judge. Just maybe pay attention to it. Oh, that was a long day. I'm kind of flipping back through my notes to see if there's anything else here that we haven't kind of already recapped that we need to. He's absolutely not going to give them, the issue of autism spectrum disorder should take the death penalty off the table. It's above his pay grade. That's not for him to decide. It's a novel issue. It's an issue of first impression. Because of that, he is not going to be the one to say yes. He's going to say, if I'm wrong, the Court of Appeals can fix it, or the Supreme Court can fix it, because that's within their pay grade, not his. So I'm really, not expecting anything along those lines. And I just also find it, a little bit telling. I mean, I described the judge as slippery, and he is. And part of the slipperiness is the shifting of the goalposts. When you don't like the defense asking you to take account of certain facts, you characterize it as, well, you're asking me to make a factual determination. That's for the jury to do. But when it comes to, I don't like the way the law is going, you'll bring up the facts to suggest, that should drive your decision. And I'm pointing specifically to, well, but the historic fine motor skill issue, like that should drive. If they're not testifying, he doesn't have any capability to do the crime. He's not supposed to decide any facts about whether there's a motor skill issue or not. That isn't his role. He's already said that in other contexts that it isn't his role. He knows it's not his role. So why would you bring it up as if it's your role? Very, very difficult to pin down. And I hate to be a little bit cavalier, but he does have a background in complex litigation. We know that his background is defending doctors and hospitals, med mal types of situations. Those can be complex cases, but they're about money. They're about money. They're not about, are you going to put somebody in front of a firing squad? So the standards are a little different. And the significance of what you need to do, what your obligations are as an attorney to do your job, are a little bit different. Whether you're malpracticing as a civil attorney is quite a bit different than whether you are providing effective assistance as a capital defense lawyer. And I don't like that he seems to be conflating these things, trying to make them equivalencies. They are not equivalent at all. I don't care if your hospital gets a judgment for a couple $1 million that, by the way, their insurer will pay for anyway. I don't really care about that. It's not that big of a deal relative to somebody getting stood up against a wall and shot and killed. That's kind of important. And this is why I often just don't love when civil lawyers end up presiding over criminal cases, especially serious criminal cases, things like death penalty cases. They don't have the background for it. And they also rarely have the humility to recognize that your experience defending hospitals and doctors does not translate to defending somebody who may be put to death. It's not the same thing. Well, that was a lot. I'm surprised they got through everything, but he really ground it out, didn't he? He really really pushed through and got it all done. Oh, I should have kept track from my Substack. I mean, of course, we don't have the actual rulings yet. I think we got a pretty good idea the way that they're going to go. But I did put out all my predictions for how I thought he was going to rule on them, and so I'll be interested. I'll of course be interested in seeing my own record. How well have I read this situation in this courtroom with this court? Kind of have a feeling I'm going to end up pretty close, but of course I think that. Of course I think that. And I guess we'll just have to wait and see till he gives us all these written decisions that he's been promising. But by and large, I think he's not going to grant most of the defense motions. He's going to let in most of what the state wants to let in, and maybe reserve somewhat on some of these other issues. But I guess we'll just have to wait and see.
I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those, or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion, because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.
Okay, here's the thing, guys. Here's the thing. He's really having it both ways with, are they expert or are they lay? The question is their testimony necessary to explain these records? If the jury can just look at the records themselves and make that determination, they can see, oh, here's the purchase, and it's Bryan's, and he did it on this date, and it was delivered on this date, etc. They don't need somebody to testify to interpret the data to tell them that. They need somebody to interpret the data and tell them that when it is not just an obvious fact that somebody can look at the record and ascertain for themselves. If that's all it was, it would be another one of these self-authenticating records. That's all that they would need. It's on the list. It's on the list of their self-authenticating records. It's because they are not facially obvious that you need somebody with special training and expertise, knowledge about what these records mean, that they're going to then tell the jury what they mean. The jury can see for themselves what they say. So that's why it's expert testimony. and not lay testimony. That's how I understand it. They're not here to just read out what the records say. They're there to tell the jury what they mean. That requires an interpretive step, and it requires special knowledge that the jury doesn't have. They can't just do it for themselves by looking at the records with their own eyes. So that's why it's an expert witness issue, and it is not just a fact issue. Does that make sense? Seems very, very straightforward to me. But the judge is very, very slippery. He's very slippery and really moves the goalposts. Because, yeah, if they're just lay witnesses, they shouldn't be able to offer opinions about it at all. The documents should speak for themselves, and that should be the end of it. Do we think that's going to be the standard that gets applied at trial? I'd be kind of surprised if it is. If these witnesses can just get up there and read the Amazon records, why would we need two of them to do that? Why would we need that? We wouldn't need that. So it's not going to be the same standard when we get to trial. Oh, that was pretty aggravating.